Hello friends, welcome to CEC Gurukul Live Lectures. Dear friends, today in this session we are going to talk on intellectual property right. Today we are going to discuss on national IPR policy in India. We are going to talk in detail about the evaluation as well as what road it is showing to us, that is what these policies are giving us advantage. So friends, for the discussion of the topic, we have with us in our studios Dr. Ashwini Sewal. Dr. Ashwini Sewal is Assistant Professor in IT and IP Laws, Faculty of Law, University of Delhi. Dr. Ashwini Sewal is a prolific professor and he is always ready to give in-depth knowledge to the students because he believes what he has attained should be disseminated to the students. So through the live platform of CEC, he makes tremendous efforts. Friends, if you wish to ask questions from Dr. Ashwini Sewal on today's topic, feel free to talk to us through our toll-free number. Our number is 1800110430. I repeat, our number is 1800110430. Now, I would like to welcome our guest, Dr. Ashwini Sewal, and would request him to explain us the topic in detail. Hello, sir. Welcome to the lecture.
Thank you, Gitika. Thanks for the introduction. Good morning, viewers. Today, we are going to discuss national IPR policy in India. We are going to evaluate the policy threadbarely and we'll see what is the road ahead, because this policy is new and the first ever national IPR policy of India. We as a nation got this policy in 2016, and being a person who has been into field of IP for almost a decade now, I believe that the policy and its framework had made a tremendous change as far as the IPR ecosystem in the country is concerned. This is undoubtedly because of the efforts of the present government and their attention towards such a minutest of the issue, which supposedly is a minutest, but it has long-term implications and it has a very big role in terms of growth, in terms of its contribution in the GDP of the nation, etc. I really appreciate the present government's move of bringing national IPR policy in India in 2016. Whatever had been the key reasons, whatever had been the underlying prompting factors for bringing this policy in India, I will not gonna criticize those things, or I will not gonna see the history, because I always believe in the future, and I believe that bringing up IP policy in India was very important and the imminent step taken by the government of India. This policy changed the entire paradigm of IP ecosystem in India. It brought several key changes, phenomenal changes in the IP landscape in our country, and it had not only changed the paradigm or the restriction, the sweep of this policy or its benefits did not remain restricted to our nation. Rather, it had given us the platform where we had collaborated with several other jurisdictions, pioneer jurisdictions in terms of IP, and we have been successfully able to collaborate. We have been successfully able to bridge the gaps. We have been successfully able to make our relations with the IP rich nations in all businesses, be it IP intensive businesses or other businesses for that matter. And I have several times in my previous lectures discussed it with my viewers that IP law primarily is a business law, has implications on business, but we have never seen it happening in practical terms in India actually. Even today there are certain loopholes, there are certain sections where there is a requirement of focus from the government, from different stakeholders, but that would be certainly done the way the present government is doing, and the way present government is emphasizing on IP intensive businesses, emphasizing on IP ecosystem in India. I am pretty hopeful that there would be a very viable atmosphere in India as far as the IP is concerned, and foreign jurisdictions, multinational companies coming from foreign jurisdictions, they shall certainly be interested in investing more in India. They shall certainly be interested in collaborating with all different stakeholders in India because of our stronger IPR regime and our stronger IPR policy. In the past 2 years, I have seen a tremendous increase in the number of foreign investments, number of foreign companies coming to India, because they see a promise from our side. The perception of the world has changed for us, and we see it happening in real terms. As I shared my own experience, my dear friends, that I have been teaching and developing IP for long, 10 years almost now, I see that IP has become a buzzword now and has become a talk of the town. Every week you see in multiple cities in India, you get to see a lot of different forums are talking about IP. Say for that matter, you see departments of the government of India like Department of Science and Technology, Department of Biotechnology, and you see it's happening even in the private sector, or it's permeating even into the private sectors. Like all big fours have started talking about IP. They have started realizing the importance of IP. Or for that matter, big business confederations like CII, Confederation of Indian Industry, ASSOCHAM, FICCI, they all have started realizing the importance that is attached and associated with IP. So the attention of all the stakeholders had increased, had proliferated in last 2 years because of the sheer efforts of our government under the aegis of our government Ministry of Commerce and Industry has made leaps and bounds in reaching out to the people, in reaching out to the different stakeholders, in reaching out to budding entrepreneurs, in reaching out to startups, in reaching out to small innovators, medium scale innovators, small enterprise innovators and all. So see, in this background, I believe it's very important to see and to evaluate threadbarely the IPR policy of India, which we got in 2016. There are several objectives which were initially enacted under the IPR policy in India. So in our today's discourse, we are going to see as to how those objectives have been met, if they have been met, or where did the initiatives are failing, not materializing as such. What's happening actually, in the present day scenario, we need to see all that, and we will also look at the road ahead and what all can be done for ensuring that all objectives of the IP policy as stipulated, as envisaged in 2016 will get materialized, will come into application. Though it's a very small period, it came into the existence in 2016 and it's 2018 I'm talking about it. So it's a span of 2.5 years only, but within 2.5 years tremendous change has come. I would navigate you to the different changes that had occurred. cursorily I will tell you as to what all had happened and whether these happenings, whether these changes are for the good or for not for the good. That has to be seen, that has to be evaluated. That's why the title of the discussion is evaluation of the policy and the road ahead later. So let's first zero in on the motto of this policy. It's quite catchy, you see. The motto itself reads, Creative India, Innovative India. Rachnatmak Bharat, Abhinav Bharat. The very first thing that catches the attention, or that catches the individual's interest in this policy is its motto, Creative India, Innovative India. We have been creative enough from times immemorial. We have been very innovative enough from times immemorial. Since ages, we have seen several creations, innovations pioneered by Indians, by our rishis in ancient time, by our scientists, by our medical practitioners, by our grassroots innovators, but nobody actually paid the attention to those innovations, those creations of the people of India, and it has always been neglected segment. But this policy, by vociferously putting across the instinct of the Indians, creative Indians, innovative Indians, and by summarizing it beautifully in the words Creative India, Innovative India, Rachnatmak Bharat, Abhinav Bharat, it's suggestive of what? That we are creative to a length where we can achieve, we can compete, cope up with the creations happening across the globe. We are innovative enough to compete and cope up with the innovations happening across the globe. But since that motto, that tagline never appeared in any of the documents relating to IP ever, nobody actually realized its importance. But this first IP policy of India, which starts with this tagline, Creative India, Innovative India, it promises to all Indians, and it ensures their faith that you are creative, you are innovative. I just get mesmerized whenever I read this tagline, Creative India, Innovative India. So let me tell you a little bit of the fact sheet about the national IPR policy, which got framed or approved by Union Cabinet in 2016. The exact date is 12th May 2016 when it was approved by the Union Cabinet, and it was a historical day for all IP people in India. I don't just want to restrict that it is something which relates only to the IP people in India. Rather, I say it is a policy that was for the masses, that was for the commoners, that was for the grassroots innovators. All Indians are called creative, innovative through this policy, and their faith has been reinforced that if you are creative, if you are innovative, and if you have come up with a creation or an innovation, your work will not go into abeyance. Your work will get good protection, your work will get proper enforcement in case of its violation, your work will be valued, it would be commercialized. There was a promise in the policy to commercialize it, to enforce it, to realize and appropriate its benefits, to exploit it. So that promise of the government was to the masses, to all Indians throughout the country who are innovating and who are creating things. If we go into the background, as I promised that I would not criticize the background, but I just need to tell you the triggering factors which actually led to creation or enactment of this policy. To my understanding and to my assessment, the triggering factor, the prompting reasons behind enactment of this policy were several, but out of those several, two are more appropriate to be named here, to be discussed here at this forum. One, where India, in its history of 60 or 70 years of having a IPR regime in India, and you see having a patent regime in India, in 2012 issued a compulsory license on a patented drug of a multinational company to a generic company of India. That is the one incident that had triggered the outrage of different jurisdictions investing in India, that had actually triggered lot of criticism by different jurisdictions against India and its IPR system, IPR regime. In light of that, or to actually, you see, tell to different jurisdictions of the world that we don't, you see, disobey the international standards. We don't, you see, completely forget the international standards while upholding certain things, while deciding certain things in the country. We are fully TRIPS compliant nation. We have never done anything, and we are never going to do anything which will be TRIPS non-compliant in nature. So this policy was brought to prove to the world that we are still TRIPS compliant nation, even if we have issued a compulsory license in that case of Bayer Natco in 2012. We are still TRIPS compliant, and we have not done anything wrong or contrary to the TRIPS. And for that, there was a need of bringing a policy, because there was a hue and cry across the globe, or especially in the Western world, where you see from where we get lot of investments, from where we get lot of innovators coming to India, from where we get lot of applicants coming to India for seeking protections on their intellectual properties. So we assured them that we are a nation which is a TRIPS compliant nation, and we are a nation having a very robust IP policy existing in India. We are a nation having a very healthy IP ecosystem in India. This is the one incident that triggered actually the enactment of this policy. The another incident, my dear friends, that actually triggered the enactment of this policy, and which is for the good. I am not saying that it has caused some harm, or the enactment of this policy has brought some wrong, consequences. It had rather brought very good consequences, many benefits to the inventors, to the grassroots innovators. It enriched the whole IP paradigm of the nation. So I was just mentioning another incident of the history from where you see we got prompted, and from where we had to actually make the IP policy for the country. It was a case of one multinational pharmaceutical company, Swiss-based multinational pharmaceutical company, that is Novartis, versus Union of India of year 2013. It was a case which was decided by Supreme Court of India, and wherein Supreme Court of India basically found that their drug, which was applied by them for patent protection, did not get the patent protection because of it being not eligible to get the patent protection, or because of it being disqualified to be given a patent protection under section 3D of the Indian Patent Act 1970. It was something which can never be given a patent protection according to our patent law, according to our patent regime. But they had patent protection on the similar work in several other jurisdictions of the world, but they failed to get the patent protection in India, which actually made them infuriated. Not only them, rather many other multinational companies, all prospective investors in Indian pharmaceutical sector, they all got retracted, they all got infuriated, they all were not willing to invest, they all were backing out from future investments because of one simple reason, that Indian regime prima facie looked to them as a contrary regime to, or as a, you see, anti-IP regime for their IPs or for their intellectual properties. But we as a nation realized, and our government, I appreciate the government's move in that they realized the need of bringing the policy, and they actually did it. They actually brought the policy in 2016 because of these two triggering issues or two prompting factors. As I said, that it is the first ever policy in India on intellectual property rights, and this policy has been enacted to lay the future roadmap of IPRs in India. Well, my dear friends, this policy is also futuristic. It has not seen as to what had happened in the past in country. Undoubtedly, they took the lessons from the past in framing, in evolving this roadmap of intellectual property rights in India, but they have not talked about the past, and they have not cribbed about the past. That cribbing does not get anything, does not bear any fruits actually. So the government actually brought the future roadmap of intellectual property rights in India by purview of this one single policy, or first ever IPR policy, National IPR Policy of India in 2016. This policy has also been created to recognize the abundance of creative work and innovative work being created in India, and to recognize the abundance of creative and innovative energies flowing in Indians or among the Indians. See, I have several times, reiterated the fact, my dear viewers, that innovation, creations are always not supposed to be at par with rocket sciences. There is no need to always bring, rocket sciences, and only then you will be eligible to get the patent protection. It's nothing like that. Even if you are coming with the solutions to the simplest or to the smallest of the problems being faced by the people, by the society, even those things can be given the protections under the intellectual property system, intellectual property regime. Every creative work, every intellectual offshoot which squarely falls within the subject matter of different intellectual property legislations can be squarely given the protection under the IPR regime. So abundance of creative and innovative energies are flowing among Indians. They are to be given some protection, they are to be given some assurance and some monetary appropriations too simultaneously, because without incentivizing, without monetarily remunerating people, it is difficult to keep them, or it is difficult to stimulate their creativity for future works. It is very difficult to bring in energies into them to create more. So the policy actually recognized the factum of different innovative energies and creative energies flowing in India, and accordingly they brought a vision statement, and the vision statement of the policy is as follows: an India where creativity and innovation are stimulated by IP for the benefit of all, an India where IP promotes advancement in science and technology, arts and culture, traditional knowledge and biodiversity resources, an India where knowledge is the main driver of development, and knowledge owned is transformed into knowledge shared. It's such a vision, it's such a beautiful vision statement, my dear friends, encompassing creativity and innovativeness of the Indians, and it is also encompassing IP's importance into their creativity and innovation. It says that stimulant for creations, innovations occurring across the globe, rather occurring not only in India, across the globe, is IP, is intellectual property. And it benefits all. It just does not benefit the one who has got the protection. Because I have reiterated it in many of my lectures that IP protection is a monopolistic in nature, but this monopoly is not absolute one. It is a monopoly which is a restricted monopoly in nature, or you can say it is a monopoly which is limited in terms of time, limited in terms of territory. So it benefits all by encouraging them, by providing them the stimuli for creations and innovations. And then it benefits as a corollary the masses, because the benefits gets percolated to rest of the society automatically after the invention comes to the public domain. The vision statement also encompasses that intellectual property promotes advancement in science and technology. Undoubtedly, science and technology is the field where we see a lot of new technologies and new developments taking place every day, and technology is something which is advancing leaps and bounds in comparison with the pace of technological developments that are taking place is phenomenal, is unparalleled. But still, you see, legislature is trying very hard, lawmakers are trying very hard, judiciary is also trying very hard to cope up with the different technological developments. It is also encompassing the fact that IP promotes arts and culture. When it says it promotes art and culture, it is referring to copyright. When it says that it promotes advancement in science and technology, it is referring to patent primarily, to designs, to trade secrets, to biodiversity, to plant varieties protection, etc. It also says that IP promotes traditional knowledge and biodiversity resources. It is specifically, delineated here that traditional knowledge gets promoted because of the IP. And I have no doubt that it actually promotes, traditional knowledge. But I also know, and I also want to put across to my viewers, that there is no legislation as on date specifically, explicitly covering traditional knowledge and providing any protection to the traditional knowledge. I don't say that traditional knowledge has been completely left out by the legislature, has not been, addressed at all. I don't say that they have ignored traditional knowledge, but as on date there is no legislation on traditional knowledge. But as far as the traditional knowledge and the outcome of the traditional knowledge are concerned, protections are available, laws are available, but there is no IP law. There are laws which can be invoked in the cases of theft of traditional knowledge, in the cases of misappropriation of traditional knowledge. But I still believe that IP promotes traditional knowledge, because many tribes from India are very creative by their inherent nature, and many tribal people in Chhattisgarh, in other parts, in Odisha, or for that matter in hill regions of our country, they are very creative, they are very innovative. I know that they don't know this much, that IP is something, or intellectual property is something which gives them a direct benefit, or from where they can appropriate a direct benefit. But they are also being supported by help groups, they are also being encouraged to get IP protection, and there are several schemes of the government which actually try to reach out to these tribal people, or to reach out to the people coming up with the traditional knowledges. The vision statement also encompasses and also envisages that knowledge is the main driver of development, and realizing this, that knowledge is the main driver of development in itself, is like, you see, achieving an end, because a society which pays adequate heed, adequate attention to knowledge goods, to outcomes of knowledge, that society will never fail in its promises. That society will progress exponentially, because they have realized that knowledge goods are as good as physical goods or owning a physical space. They know that knowledge owned has to be transformed, has to be percolated to the masses, and that's why this vision statement of the IP policy reads that knowledge owned is transformed into knowledge shared. As far as the knowledge sharing is concerned, my dear friends, the knowledge sharing in the cases of intellectual property starts at the very first stage, when the creator or the innovator of the work goes to the office of intellectual property. He or she has to disclose. For example, in the case of patents, they are supposed to make a mandatory disclosure of their work. That disclosure goes into the public domain, and that is how, you see, the promise of knowledge sharing gets fulfilled. Knowledge gets shared. I'm not saying that others will be allowed to appropriate that knowledge for economic goods or something, but I am pretty sure that that much of, you see, sharing of knowledge, that one can easily refer to the works of others, one can easily see the developments in the fields by referring to the works of others, is adequately sufficient to give a boost to future inventions, to future innovators, to future creators. So that knowledge sharing is one aspect, and then another aspect is knowledge sharing with the people in need, and that has taken place, is taking place by several measures which are inbuilt under the IPR regime in India. For example, compulsory licensing. Through compulsory licensing or other such measures, knowledge is being shared, or is at least being facilitated to be shared with the masses at an affordable and reasonable prices. So this vision statement of the National IP Policy of India is adequate, is all encompassing, barring one or two things which are yet to be materialized. Rest of the promises, I believe, have been fulfilled by the present government and by the policy makers under this regime. Let's move ahead and see, after the vision statement, they had a mission statement also under this National IP Policy. If you look at the mission statement, it reads that IP policy has come to stimulate a dynamic, vibrant and balanced IP rights system in India. By using these words, by using these peculiar terms, dynamic, vibrant and balanced IP rights system in India, the policy makers had done their job beautifully by assuring to the masses, by assuring to all the beneficiaries of IP ecosystem that our goal is not to create any IP policy which would remain static. Rather, our goal is to bring in a policy which will be dynamic, which will be vibrant and balanced. Dynamism is necessary because no policy can afford to sustain if it is static. There has to be dynamism. It has to have a vibrancy, and it has to be, of course, a balanced IP system and IP policy. And IP policy, by assuring this, has done several consequent changes under the intellectual property rights system in India, which has fulfilled the promise of dynamism to be there in the IP rights system, vibrancy to be there in the IP rights system, and balance to be there in the IP rights system. I would give you many examples, specifically from, off-late examples, specifically of 2017, where we have seen a lot of changes in the trademark rules. We have also seen draft patent rules of 2018 of late, where you see the legislature, in consonance with the policy, is bringing more dynamism, is ensuring vibrancy, is ensuring balanced system in India. And this is needed to foster creativity and innovation, and thereby promote entrepreneurship and enhance socio-economic and cultural development. If there is no balanced IPR ecosystem prevailing in the country, it will never foster creativity and innovation. It will never promote entrepreneurship. See, the thrust at this juncture in the country is to promote entrepreneurship, is to enhance socio-economic and cultural development, and that can be achieved only by having a balanced IP rights system. This is one of the major collaterals. I am not saying IP alone will promote entrepreneurship. Don't misread me or misinterpret me, but I am pretty sure that it is one of the most important collateral or a component which brings in what? Entrepreneurship, socio-economic and cultural development, and creativity and innovation among the masses, and which is very much needed for a society to grow and prosper. A society never grows and prosper if it lacks in promotion of entrepreneurship, if its policies are lacking in enhancing socio-economic and cultural development, if its policies are ignoring the role of creativity and innovation. I can give you example of many societies. Say, for example, Japan is a small nation, but their IP rights system is so robust, is so promising, is very adequate, and we have seen Japan's phenomenal growth. We have seen Japan's advancement. We have seen Japan competing with US, irrespective that it had faced lot of hardships, lot of, devastations being a nation, but it had not failed its masses because their thrust is on creativity, is on innovation. They actually promote entrepreneurship, and their IP ecosystem is such that even school kids over there are taught entrepreneurship, the role of IP, and there lies a huge potential even in India as far as entrepreneurship is concerned. We are population wise the second biggest nation in the world, and there is no dearth of talent, there is no dearth of creations, innovations happening across the country. It's just a matter of realizing that it is something that can be given up protection under the intellectual property system. It is just a matter of our IP rights system to be so viable, to be so accessible to the masses, that it immediately brings in even the marginal people, even the marginal innovators and creators under its vision. Because entrepreneurship is one of the major collaterals, as I just mentioned, and present government I am saying again that, you see, our ministry, which is taking care of IP primarily, Ministry of Commerce and its wing, Department of Industrial Policy and Promotion, that is DIPP, under the aegis of the present government, is doing wonders in promoting entrepreneurship, is doing wonders in enhancing socio-economic and cultural development. And we are really witnessing it happening across India, around us, because filings have increased exponentially in last few years. The procedures for IP filings has been simplified to such an extent that even a lay person who has innovated something or created something can file the trademark application easily, can file the patent application easily. Patent facilitator centers have been opened, different IP cells have been opened in different universities of the country. Cultural cluster innovation centers have been opened for the cultural development, for the economic development, for the entrepreneurship development. So there has occurred a change, and it's occurring, it's ongoing. In next 10 years, I am hopeful that we would also compete with the leading IP nations of the world. I hope, you see, you don't misread me as over enthusiastic as far as my assessment is concerned, but the way things are moving and the way, you know, the attentions of the stakeholders is being derived towards IP, it has become fully IP centric. I am hopeful that things will certainly gonna reap very positive fruits, and things will certainly move and fast, expeditiously change. If you look further, under the mission statement itself, the focus is on enhancing access to healthcare. Now it is coming to specific areas where there is a need of primary attention to be given. These are the sectors which are to be addressed primarily, immediately, on an imminent basis. And our IP rights system has to be such which would focus on enhancing access to healthcare, food security, and environmental protection, among other sectors of vital socio-economic and technological importance. And this is happening in real time. The focus has shifted toward healthcare, food and security. I again say to my viewers that don't misinterpret me saying that IP is the only thing that actually leads to improvement in health sector or access to health sector. It leads to ensuring food security, etc. I'm not saying so, but it is one of the major components and collaterals to be kept in mind. And you see, according to the national IPR policy, there was a mission statement, and in pursuance of that mission statement, adequate attention is being given by several segments of the government towards addressing these primary sectors, or towards addressing the needs of these primary sectors like healthcare, food security, environmental protection, by intellectual property creations, by intellectual property innovations. Say for example, the patent law through its compulsory licensing regime has enhanced the access to healthcare. And this is something, I'm not saying that it has come just because of the IP policy, but we have got a assurance through this policy that we, being TRIPS compliant nation, have to have a policy which gives adequate attention to sector of healthcare, which has always been into dismal state of affairs. But IP is a tool through which access can be enhanced. Through its legislation, access to healthcare can be enhanced. Through its appropriation, access to healthcare can be enhanced. If a person who is a person in the field of pharmaceuticals is engaged into research of creating a new drug or is doing a drug discovery, he is assured about the protection on his work if it qualifies for the protection. That assurance and the assurance of the enforcement of his work, assurance of valuing his work for future commercialization is actually enhancing the access to healthcare, and so on and so forth. Let me take you to the peculiar objectives or particular objectives of this National IP Policy of 2016. There were 7 clear objectives, my dear friends, of the National IP Policy, which are as follows. The first is general in nature, IP awareness, outreach and promotion. It used to be there earlier also. This component is not new, but I am sure that many of you will agree that IPR awareness and outreach and promotion is still needed. The enormity of outreach, enormity of awareness or promotion, the length of outreach, promotion, awareness may vary, or you may say that since you see it's been long now that government bodies have been involved into awareness on IP, there is not much need of sensitization and awareness, but it is still needed in certain sectors. It is still needed in far-flung areas of the nation. It is still needed to be told to the grassroots innovators. It is still needed to be told to the small medium enterprises. It is still needed to be told to the budding entrepreneurs and startups. Those who are into the field of the IP, they are aware, I don't deny this fact, but I am talking about those innovators. Innovation is not a bounty of only educated people. It is a bounty of, or a cup of tea of a person who is just innovative. He may be a person who may be a school dropout. He does not need to have a formal university or a college degree. So he does not, or he may not know about intellectual property system prevailing in India. So people like him needs to be informed about this aspect. So awareness is still needed. I'm not saying that India is at the nascent or is at the infancy of awareness. We have done a lot of awareness. We have seen a lot of awareness happening around. It's still needed. It will proliferate with the time. The next objective under the scheme was generation of IPRs. And for generation of the IPRs, I again say that stimulation is necessary, encouragement is necessary, enforcement is necessary, commercialization is necessary. And the last part that I just mentioned, commercialization. To me, commercialization is one of the most important factors for the generation of IPRs. Because if your work, even after getting the or fetching the protection under the IP regime, is of no commercial exploitation, is of no commercial value, no more IPRs would get generated, and you won't feel like generating more IPRs. So commercialization has to be a very important aspect, or is an important aspect, and there's a need of, you see, giving a thrust, giving a adequate attention, requisite attention to the generation of IPRs through commercialization. And I will also talk about the key things that can be done in order to encourage the commercialization, in order to enhance the commercialization of the IPRs in the chapter called Road Ahead later. Then there was another objective of the IP policy, that is legal and legislative framework. The objective reads to have a strong and effective IPR laws which balance the interest of the right owners with larger public interest. See, there has come again the manifestation of IP right system to be balanced It has to be balanced. There has to be, you see, provisions which take care into consideration the interest of the public on the one hand and the owner's interest on the another hand. So both things has to run or go in tandem. It must not be a legislation or a legislative framework which just pays attention to the rights of the owners. It just encourages owners only and does not pay heed at all to the public interest. That is one of the most important aspects to be taken into the mind, my dear friends, that the law, the legislative framework, according to the objectives of the policy, has to be balanced one, which strikes a balance between the owner's right and the right of the public at large. And we have seen that happening. But I again say there is a lot more that can be done in this direction. There is a lot more efforts are required. There are a lot more, you see, initiatives are required from the side of the government, which I'll speak in my discourse on road ahead. Then the policy, through its one of the most important objectives, talks about administration and management of the IP. IP management has also been recognized as one of the key objectives of the policy to be met within 5 years of time period of this policy, because the review of the policy will take place after 5 years after its enactment, and within that 5 years of span, IP management is to be met. When I talk about IP management, you see, when I read about the IP management, my dear friends, I see not much happening across the country as far as the IP management is concerned or its administration is concerned. But you see, there is a need to do a lot of things. For example, when it comes to IP management, I believe that like foreign multinational companies, our Indian investors, our Indian innovators, or our Indian IP intensive businesses or business houses, they must also keep IP managers, or there has to be a IP managers wing into their respective organizations, because all services which are centric towards IPR or oriented towards IPR, they are to be strengthened, and that aspect has to be looked after fully. If it is not looked after fully, I believe owning an IP will not serve the purpose unless it is managed properly. Owning of the IP is one thing, but its management through its time period is another important factor. It has to be managed adequately, it has to be managed with full-fledged system. That can be a sectoral system, evolved, devised at the level of the company, at the level of the multinational, at the level of the Indian company, investors, etc. But there has to be something which pays heed or which actually focuses on management of the IP after owning it. Management includes many things. I mean, management includes, you see, its enforcement, its protection, precluding it from prospective violations or its infringement, etc. It also includes its valuation, I mean valuing it for commercialization. That has to be done at the management level. So that is one of the important factors that was realized by the IP policy makers and the think tank that was formulated to come up with the IP, and they have adequately, you see, addressed it. Then there is another objective, commercialization of IPRs, to get value for IPRs through commercialization. As I said, my dear friends, that IP acts as a collateral for growth, for investment, for competition. Recently, World Bank Forum has come up with a report on ease of doing business, and you will be startled to note, my dear friends, that Indian position has improved. 30 positions we have jumped in 1 year, in mere 1 year, in terms of our ecosystem for ease of doing business, or in terms of our infrastructure for ease of doing business. And you know, reaching to a position that is 77th, I guess, in that report which is below 100. We have never come below 100 in ease of doing business report. That is our annual report that comes annually from World Bank. But this year we have reached to that slot, and IP has played a very crucial role in making our nation to reach to that level. And as far as the policy is concerned, I must say that because of this policy, we have become visible to the world. We have been able to change the perceptions of the investors. We have been able to change the perceptions of those who used to think us non-compliant nation or non-TRIPS compliant nation. So IPRs are actually adding a lot of value, and I say that this collateral, this component has to be there even in the balance sheets of the companies. It's missing from the balance sheets, which is startling to note. It has to be there in the balance sheets because it is also a property, my dear friends, like other properties. Whenever assets are audited of a company, all physical assets are audited, balance sheets are seen to value the companies or to evaluate their assets. IPRs are missed. It is something which is very disappointing. Many nations have started realized and had realized it long back. They have brought IPRs into balance sheets. They have started auditing companies on the basis of their IPs, and you won't believe that many of the world's pioneer entities, companies, are having their so much of, value because of their major IP portfolios, because of their huge IP portfolios. Many of the companies have, for example, PepsiCo or Coca-Cola. These companies generate a lot of value through their trademarks, and it is something which is, a public knowledge. Everybody knows. There are many companies who have 80% of their total asset value coming from IPRs. It is something which is not imaginable at all in India, because that component is ignored from the balance sheets, from the auditors. It does not come into your assets. Though it is a knowledge good, it is an asset and it is as good as your physical property. But since its term is limited, since its value is only for a specific period of time, say 20 years in the case of the patent, but for those good 20 years, I think that a value must be attached, associated with those goods, and it should accordingly come into the balance sheets. It should accordingly be assessed while assessing the entire value of the company, of the assets of the company. So with this note, my dear friends, I pause here because our time has finished. I would also like to meet you again in the next session and would like to apprise you about the later part of this discussion. Thank you very much. Have a very good day, my dear friends. Thank you.
With this note, thank you, sir. Thank you so much for giving us this session. Friends, you're requested to write to us at info.cec@nic.in for any queries or feedback. We are going to meet again soon. Till then, take care. Goodbye. Thank you, sir. Thank you once again.
Thank you, Gitika.